And I don't know why people think disciplining children equals, let me pull out a belt, let me beat you with a belt, because this wasn't let me tap you with corrections. And now you get an attitude with me. And let me just tell you, I will send you quick, fast, and in a hurry as a condition of your probation to the Bexar County Jail.
He called his 8-year-old son dramatic, but the judge had a much different word for his actions.
Yes, Your Honor.
All right, the court is calling 2023 CR 1952, State of Texas versus Michael J. Duron. Can I have parties announced for the record for the state?
For the state.
Defense?
Sorry, Sean Sheffield for defendant, Your Honor.
And are you Mr. Duron?
Yes.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Duron, I'm showing you what's entitled application for deferred adjudication or community service. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Showing you what's entitled court's admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with injury to a child, bodily injury intentionally and knowingly? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? You need to speak up.
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Duron, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state recommends deferred adjudication. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of your plea bargain agreement?
Yes, ma'am.
Defense?
Yes, sir.
State?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 3 years. There be the BIPP course, no harmful or injurious contact with Michael Duron. Did you understand those are recommendations by the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offer states exhibit 1 and all attachments.
No objection.
Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review this with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything that you wish to say on behalf of your client?
Yes, Your Honor. As you've sure read, this is a case, it's a little older, over a year old, Judge. During that time, he has worked with CPS. The child was never removed from his custody. Child did very well with him. He did everything required. They ended up closing the case. It was not a legal case, Your Honor. He is just requesting, he understands he did wrong, that shouldn't have happened. And he's actually also already started a family violence class also, Your Honor. So we're just requesting the court to follow this recommendation.
So were you the CPS attorney?
No, that was not. He, like I said, Your Honor, there was actually never a legal case, Your Honor.
Okay. Anything you have to say for yourself?
Yes, I was, that day I was, disciplining my child like a parent should. He acts dramatic and he was, trying to, I understand what I did, but I'm trying to.
Yeah, you're trying to shift the burden on him.
Explain.
I don't believe he's trying to do that, Your Honor, because we had discussions. He understands
Well, he's
he went
saying
way
his
too
child was
far.
asking-
He went way too far. It shouldn't have happened.
He's saying that his child acts dramatic. That's what he said. Dinah, could you, did he say that? Excuse me?
He did, Your Honor.
So he hasn't learned anything.
I disagree with that, Your Honor. Having
Well,
known him for
What have you
this
learned?
time.
I learned how to talk to my child. I'm always being there for him. He's always coming for me to advise. He gives me this random, I love you, I hug you. I'm always.
No.
Um,
Here's my thing. You told me that he was acting dramatic. You told me, and if the record is not clear, or if I'm remembering things incorrectly, please correct me. But you told me that one, your child is dramatic, and two, you started by saying, I was disciplining my child as a parent should. That's what you told me. So how does disciplining a child as a parent should result in a child having a belt mark on their face? And was that being dramatic? Because that's what it says in the police report, that he had a belt mark on his face, belt mark on his arm. And how old was your child at this time? What, 9, 8, something like that?
yes, ma'am.
So basically, what you have taught your child is that your child needs to fear you, which means that if your child accidentally sprays something in somebody's food, he can't tell you because he knows what's going to end up happening. He's going to get hit with a belt across his face. And I don't know why people think disciplining children equals, let me pull out a belt, let me beat you with a belt, because this wasn't let me tap you with corrections. And now you get an attitude with me. And let me just tell you, I will send you quick, fast, and in a hurry as a condition of your probation to the Bexar County Jail or either to the state jail facility. And you can see how your discipline works with other people at the jail if it comes to that. So I'm telling you, when you beat a child, this wasn't discipline, this was a beating. When you beat a child, what they learn is to fear you. And you are a grown man hitting on a child. If somebody, let's say, for example, you're at somebody's house, they invite you over, you're sitting at the table and you drop your food on the ground or on the carpet, and it's white carpet, and they get angry. And so they take a belt and slap you across the face. And they tell you, well, I'm just disciplining you because you knew this is white carpet. I told you to be careful not to spill anything on my carpet, and you did. You know what you would do? You would call the police and you would file charges because that person hit you. So you've gone beyond disciplining your child. And I don't know why people don't understand that. And you can say your child out of the blue is saying, I love you and all of this. Sometimes, you know why they're doing that? Because they're walking on eggshells. Because you have put fear into this child. If this child were to pick up a criminal case, you know what they'd come to court and tell me? His attorney would? He suffered trauma. Well, what trauma did he suffer? Well, his father beat him. They're not going to come in and tell me the father disciplined them. They're going to come in and tell me my father beat me. And that's what this was.
It wasn't like that, Judge.
Did he have a belt mark across his face?
I can't recall. I don't remember. I remember him just ducking, and usually
Oh, just ducking.
usually I try to punish him, send him to his ground him, take away his video games because he does wrong. He understands that.
So why did you beat him with a belt across his face? Is it because the girlfriend came to you and said, this is what happened?
No, that wasn't the case at all.
Yeah. So why did you beat him?
It was just he was acting up during the day, and it was
Doing what?
well prior to that he had we had went swimming. He had jumped in the deep end, and I told him don't do that. So I went after him, and then when we got out, he kept on picking on his sister and my daughter. My daughter's like, Dad, he keeps on messing with me, keeps on pushing me, acting like he's gonna push me into the water. So we go out to get food. We come
Who's
home.
your daughter's mother?
The same parent.
Who's the same mother?
Yes, ma'am.
Okay. Finish your story.
And so my daughter is like getting irritated, and I'm just like, calm down, because he has ADHD. And so we get home and we finally sit down and for dinner, we say our prayers and everything. And he decided to get some Lysol and disinfect her burger because it was during COVID. And so he was just acting up. I sent him to his room. He goes and slams the door, and I'm like, behave. My daughter comes back crying, that he had done something to her toy box, and said, son, what's wrong with you? And he was just like, just very quiet. I said, well, tell me what happened. Just quiet. And so I didn't mean to hit him as hard. I didn't mean to hit him at all, but I was trying to tell him, like, you need to calm down, you need to behave already, you need to, stop messing with your sister. Don't go trying to push her into the deep end. He already went into the deep end and kind of sort of drowned. But I was able to, save him. So I wasn't trying to target him. I was trying to make him understand that it's not okay for you to continue acting like that.
And what have you learned from your parenting classes? Because I'm assuming CPS gave you parenting classes.
No, it's voluntary.
Did you do parenting classes?
Yes, ma'am.
Who did you do parenting classes?
It was compadre.
Okay.
So,
I like compadre.
and I learned a lot.
What did you learn?
I learned how to calm myself down. Don't explode. Take a deep breath. Wait a little bit. Talk to him. Settle him down. Right. Try to understand where he went wrong. Where we both can try to understand each other. He is very active. He's very compulsive, and that's part of the ADHD that he has from his family, from his mother's side. My daughter is just like me. We're very chill. We're very calm, and he just.
See, you keep saying, so the daughter has the same mother as your son?
Yes.
Okay, and where is the mother in all of this?
She hasn't been active. She has never been present in such a life. I took custody of them when my daughter was out the hospital because she was born with methamphetamine in her system. My baby mama was a drug addict, so
Mother of your children.
yes.
All right, are you employed?
Yes, ma'am.
What do you do?
I do renovation and remodeling, demolition work as well.
All right, this is what the court is going to do. 4 years deferred adjudication. There's an affirmative finding of family violence, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. I'm going to give you 200 hours of community service restitution if you provide your certificate or proof that you completed the compadre parenting course. Then I will deem that the community service hours are satisfied.
Thank you, Judge.
There's to be regular reporting by Zoom or in person, regular UAs, field visits, random, one time a month for 3 months. Then if all is going well with the field visits, then we will decrease it to one time every 3 months random. And that will stay in place until further notice. There's to be no harmful or injurious contact with Michael Duron. And probation, is there some, I don't think this is a BIPP issue. This is more a family issue. Is there some type of family counseling that can be?
John, I'll look into, I can look into it. And, yeah, I can look into it.
Your Honor, he has also started a class, so maybe you can give that to them and see if that would work.
Yes. So I just don't think this is a BIPP course situation. This is more family dynamic situation. All right, probation. Is there anything else he needs? Is there anything else you need from the court to be successful?
No.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Good luck to you. You're gonna have to do better.
Thank you, sir.
And you're gonna have a lot to make up to with your son, because believe it or not, I know you say things are better, yes, but your son is always gonna remember that. So you're gonna have to make it up to him and let him know.
He saw me get arrested in March and he's like, Dad, I didn't mean to get you in trouble. And he's like, Dad, every time the cops come, he's like, are you gonna go to jail?
Yeah.
I don't want him to be thinking that.
No, but see, you gotta turn that around and not let him make it his fault, because him saying that is him saying it's my fault, and it's not. Okay? All right, good luck to you.
Thank you, Judge.
In the case of the state of Texas versus Michael J. Duron, the courtroom witnessed a tense exchange regarding the boundaries of parental discipline. Duron was charged with a third-degree felony for injury to a child after leaving belt marks on his 9-year-old son's face. When the defendant claimed he was merely disciplining his child for being dramatic and acting out due to ADHD, Judge Boyd delivered a sharp rebuttal. She emphasized that hitting a child across the face is not discipline, it is a beating. The judge pointed out that such actions instill fear rather than respect, potentially leading to long-term trauma. Despite the severity of the incident, Duron requested deferred adjudication, citing his participation in voluntary parenting classes. Judge Boyd ultimately sentenced him to 4 years of deferred adjudication with a permanent finding of family violence. She ended the session with a somber reminder. The defendant must now work to convince his son that the father's arrest was not the child's fault.
If you enjoy real courtroom drama and true legal cases, please like this video and subscribe to Boyd's Court.